All right, so you've made it through 12 chapters so far. Congratulations, right? You're hanging in there, pretty much halfway through. Now we're finally getting into the bankruptcy petition. Now, I will let you know, I'm going to be doing a complete set of videos regarding the bankruptcy petition and going over the forms that are available. This, I'm actually going to be doing the PowerPoints that go over this issue. So the best way to handle this is just look at the PowerPoints, understand some of the concepts, but if possible, either have a dual screen or have the forms printed out so you can start seeing all the different sections of the forms that I'm talking about. This is important because I want you to understand that completing forms is not the difficult part about doing all this when it comes to bankruptcy. The difficult part is being able to spot issues. So obviously where it says put your name, right? It's not too difficult. But the issues that can come from a name alone could be complicated. So you're thinking, well, how's that possible? You'll see when you go through all the different steps, but try to have the forms with you, or if you're using certain software like Best Case, whatever it might be doing, have those sections with you. Maybe just listen in, but if possible, also have the video running so you can actually see the sections I'm highlighting. Maybe play it on your phone or something like that. All right. So let's get ready and jump into chapter 12. All right, so we are now reviewing chapter 12 of the textbook. Now, my suggestion, as I said before, start looking at the petition to get a better idea. I will be doing separate videos on just going through the petition as well, but I think it helps to see not only what's going on here with the PowerPoint, but to also start focusing on some of the issues. Now, I'm going to start off with the name. You would think something as simple as this, and this is why I keep saying it's not just completing forms. It's seeing what the issues are ahead of time and being able to prevent any issues from moving forward. So when it comes to the name, don't just go by what the client says. My name is Bob Smith. Because when they go to court and the petition was written as Bob Smith and the client's going to approve it anyway, the trustee is going to say the name on the license is Robert Smith. So amend the petition, come back another day. Client's going to be upset. The lawyer's going to be upset. Everyone's going to be upset that more time and money has to be devoted to this. So make sure to compare the credit report to the driver's license and social security. And definitely make sure that the social security is exact. A lot of times, we make a mistake. If the last four numbers are, let's say 5939, we say 5993. It's a simple mistake, but that simple mistake means bankruptcy was filed under somebody else's social security, and then there's other steps that have to be taken to fix that. Okay. Now, besides the matching names, tax returns, look at everything. Make sure the addresses match as well. Why is the client giving you one address for his driver's license and yet another address for his tax returns or driver's license? The only reason I say that's an issue, maybe the client just says, I just moved or whatever, and that's fine. But then the other issue is, well, first we can even go to this. Did they file in another state before? I mean, were they living in another state before? Then remember, we have the 730. Let me jump over here to the second one. Then we have the issue of residency versus domicile, and I'll go over that obviously in the second slide. But the other issue as well is sometimes clients just rent out their house. And in their mind, they have homestead exemption because that's what they claimed with the county, but that has nothing to do with bankruptcy court. There's two different things. Now, I said also look just to make sure that we comply with the 730 and 180-day rule. Remember, that's going to decide ultimately which exemptions are going to apply. If you've lived here less than 730 days, then we have to apply the exemptions of the other state. Which state is better? You have to look at the exemptions and take it from there to have a better idea. Now, I do want to go over the issue in the textbook. I think I reference, athletes who might have a team where they reside somewhere, but their home is somewhere else. And that's the reality. Where you reside and where you live, two different things, even though it kind of sounds the same, right? What's the difference between residency and domicile? Well, this is where you're residing at the time, but the domicile, let's call it your home. So if a client has homes in two different states, which I've come across that before, especially living so close to the border of Florida and Georgia, then the issue is which state is the best, which one should be claimed homestead property, etc. If you want an excellent example of that, and let me make a notation here to put it into the links of the file. Rudy Giuliani had that issue, and this link will be straight to my blog. Rudy Giuliani had that issue where he was claiming he lived in Florida because obviously Florida has the full homestead exemption versus the condo that he had in New York. He was saying he doesn't really, spend that much time there. So I've written a lot about Rudy Giuliani only because it's an excellent example of like all the issues you can actually face in a bankruptcy case. So I'll put the link, just check it out so you have an idea of some of the issues he was dealing with in his case, but would apply to all your other cases. Okay. Now, um, when you go to court, there's nothing wrong with it. The client moved recently, especially if it's a rental. That doesn't mean it's the end of the world, but update it. I say update it because the trustees are going to sometimes say, I better see it updated within the next 10 days. Typically, they're citing state law that says if you've been residing in that state or you move location, you have to update your address as quick as possible. The reason they say that is because when you get pulled over by police, guess what police are going to do? They're going to give you a ticket for not having an updated address. So you'll get a ticket for whatever, let's say speeding, and now another one for not having an updated address. That's going to increase your court cost. So make sure the addresses are updated for the client. Now, when it comes to the issue of fees and costs, this really depends on how the law firm works. Just make sure that the money is, the ledger systems are accurate, because if too many cases are filed and then all of a sudden there's a negative balance on the trust account, the bank will notify the state bar association, and now your boss or the attorney has a big problem on their hands. So trust accounts are supposed to be reconciled every month, but we get busy, and I'm going to be the first one to say we don't always do that. So it could be an issue. Now, remember that simply fees belong to the lawyer. That's how the lawyer gets paid. That goes into the operating account. From there, they pay staff, internet. They pay for everything through the operating account. Trust account is not the money for the lawyer. So I don't care if we're talking about a personal injury case, or we're filing a divorce case, or if we're talking about bankruptcy with the two classes. Some lawyers, I always used to collect it directly from the client in my costs. Some lawyers might say, have the client pay for it out of pocket, but there's still the filing fees. And the filing fees go here. So very simple. The last payment was $1,000. There's going to be a combination of fees and costs there. So let's just look at this real quick, because trust accounting is so important, and that's how a lot of lawyers get into trouble. So let's just suppose it's 500 and 500, 500 fees, 500 costs. Well, the bottom line is this part here goes into the trust account, and once the funds clear, the 500 that belongs to the lawyer simply gets transferred. So I used to do transfers at the end of the week, unless I got a recent check that day and had to wait till the check clear. Okay. Now, I've talked a lot about prior bankruptcies. Always make sure that there's a good faith filing involved. You can review Pacer. Not all districts have yet, when you file, that they automatically notify you. Excuse me. I would definitely recommend just popping through Pacer, especially the client says they filed before. Even if they say it's more than 10 years ago, clients get that more wrong than right. So just make sure, and also make sure that if they filed one or the other, Chapter 7 or Chapter 13, which one would apply in this situation, so you can make sure, the time frame, if it's more than 8 years or more than 2 years, etc. Okay. Now, evictions. Evictions were part of the changes that occurred in 2005 with BACBA. Remember, bankruptcy abuse? Yeah, abuse. Prevention Consumer Protection Act. When that happened, one of the things that they changed was the process when it came to when there's an eviction pending. It's kind of like your typical eviction. There might be a legitimate reason to argue the eviction, but at the end of the day, guess what? The court is going to require that those funds are deposited. And likewise, you see here, even the landlord has to be served with the petition. There's extra steps for the landlord to be put on notice. You'll see that form when we go through all the forms. But it's no longer filing for bankruptcy and waiting it out. The money still has to come in to the landlord. Okay. Now, when it comes to credit counseling, just remember, for me personally, I like to do this when the clients made their last payment. A lot of clients are ready to go, and all of a sudden it's been 7 months and they still haven't paid your balance. And since you already paid for the cost, assuming you took it from them originally, now you have to ask them for more money, and they're going to blame you no matter what. So I prefer, once the balance is zero on the account, say I'm going to send you an email with the link and my password. Most of these credit counseling companies simply just say, you get a special attorney login and password. You pass it on to the client. They can log in, and then you get notified of the status of their cases. Okay. Now, I do remember, just going back here again. The way that I do it is I like everything just billed to my credit card. Then I transfer my IOTA to my operating, and then I pay off my credit card. That's the way that I do it. Okay. Now, for the second class, even though there is time to do it, I simply tell clients, you better do it before the 341 meeting. Um, they do have time. They don't ask me. If not, I would have to tell them the truth, how much time they have. But I just don't like to, we get busy, we forget, we might overlook something. So it's just easier to know that I have it done, because that way, when you're going to the 341 meeting, you say, oh, this was already done, and it's great. A lot of times, these credit counseling classes will file the second certificate as a courtesy. So do that, that could be a convenience factor. You don't have to chase the client. Once you get it, you see that the filing's done, because you get the notice via email. Now, finally, there is discretion when we go over the forms when it comes to the credit counseling class. There's obvious, but the problem is, like I say here, there's just too much discretion. I always like to take the approach: what if the judge, I don't care what court, we're talking civil, criminal, or bankruptcy. What if the judge didn't wake up in a good mood that day? Because judges are regular people, just like you and I. And I know people find that hard to believe, that judges, are above everything. They're not. They have issues that they all face, same issues we face every single day, and they could have a bad day. And you ask any lawyer, and they'll say, "Oh yeah, that judge had a bad day that day, and I paid for it one way or another." So while there are exceptions, I mean, there's obvious ones, right? Mental incapacity, there would be a guardian appointed. So those are easy. But physical disability, considering we can do this online, I would say don't use that as an exception to take the course. And I can't imagine, I mean, I've never been in that situation, even though in Jacksonville, there's, I think, like 3 naval bases. I've yet to come across that issue of a military member in a combat zone and having to file for bankruptcy. I think with a military member in an active combat zone, I think the judges are definitely going to be more flexible. But at the end of the day, the problem is, the judges have discretion. And while you could get a 30-day extension, again, what if the judge says, no, thank you, dismissed? Now you just have to explain too many things to your client. It is just, I know there's going to be emergency type situations, but when you look at the list, that's not available in 7 days. It is available because it's all done online. Maybe that applied at some point in the rural areas where we had to make a phone call, or sometimes even at the beginning physically walk in somewhere. That doesn't apply anymore. Everything today is online. So the fact that they even have that, I think that's just outdated. No one's going to change the rule just for that. But it being online, there's really no excuse that it can't be done. The client can finish the course faster than most likely you can finish the petition. So if it's one of these emergencies, bankruptcy has to be filed tomorrow morning, then my answer would be, why not just have the client do it right then and now, especially if they're at their office while you're busy working on the petition. Okay, so that's it for chapter 12. We're going to dig now into chapter 13. Any questions or comments, post them in the comment section below. Don't forget to like and subscribe to my videos, whether it's videos regarding the textbook or it's going to be regarding the bankruptcy petition. All my videos are related somehow to bankruptcy, debt management, all those type of issues we all face, and especially our clients. So you're definitely going to pick up and learn a thing or two. All right. Thank you. And I'll see you now in chapter 13.